Welcome, everyone, to Ladies in the Law. My name's Allison.
And I'm Michaela.
And we're back to continue discussing legal topics and making them easily digestible and just fun. So we have, for today's topic, we have building rapport with your client. And so we're going to be talking about a couple of ways to do that throughout the lifestyle of your case. So Michaela, we were talking about this yesterday, and it really doesn't start with just at the moment that you sign your case, right? Like this is continuously throughout your case. So can you kind of talk about being proactive versus reactive with communication and building the rapport with your client?
Yeah, absolutely. I think so often we are, as attorneys or as anyone working within like the legal field, it's so easy to just go through the steps, go through the motions and forget that you're actually dealing with a human being. And at the end of the day, the case is for them. And I think what's really important is to build a trust with your client. And so where that comes from is a mutual line of respect. Letting the client know like, hi, I am here and I am fighting for you. And I want to create a space where you feel comfortable and safe to open up. And so part of that is exactly what you're saying, is building that rapport. And I think a huge part of the proactive versus reactive is like my philosophy anytime I am talking to clients, and something that I'll explain to them from the get-go. So one of my first conversations with my client is hopefully like way before you're doing discovery.
Yeah.
You should make that contact with them. And I like to say from the get-go, hey, my comfort zone is to be proactive instead of reactive. What that means to me is, you know, like we are humans, we are flawed beings. There might be things that we are worried about disclosing because we might think that might negatively impact your case. But the only way it's going to negatively impact your case is if you're hiding it. And the other side, they're going to find out things.
Or not even hiding it, but you just forgot, and then now it's painted a certain way by the opposing side.
Exactly.
So
exactly. And then you can't control the narrative. So like I want to be proactive. I want you to give me all of this information, allow me to kind of curate the best way to go about disclosing it. But that's how we always operate, right? Is like by being transparent.
And I think the reason we were talking about this and then came up was, so oftentimes this happens during discovery. So written discovery, when your opposing side sends you questions and then you start answering questions about your background, questions about prior injuries. And sometimes clients forget certain things. And then later on, maybe a few months can go by and they're asked in their deposition, and you just want to be consistent the whole time. And so I think you and I were talking about, how do you make sure your client's consistent and open with you? Because sometimes it's embarrassing, right? Like maybe they have a past criminal history. And so when you do, so let's backtrack. So let's say we just signed a case and we're still in the very early phases of intake, asking the question about intake. Do you have those conversations about like, look, you need to be open and honest with us? Do you have those conversations like day one? Or
yes,
yeah, okay.
I do. I have them day one because I want to be as realistic as possible at setting expectations for myself and also for our client.
Yeah.
I want them to know like, hey, like right now, maybe something feels very personal, or maybe something doesn't feel right to disclose just yet. Maybe in your head, this is something that's hard to say, and so you'd rather have a different setting. But I want them to know that eventually, like, I want to be that safe space for them. And I feel like that starts from the jump.
100%. And I think I've seen it too when I'm working with the client. Usually it's getting closer towards discovery and you start getting into very specific questions. And I had, for example, one client that was making a loss of earnings claim. And there was something, I was sensing that he was holding back something. And then I finally asked him, like, is there something on your mind? Like 100% confidentiality, attorney-client privilege means that everything you tell me is 100% confidential. Like, please open up. And he was like, honestly, I'm not a citizen and I'm really nervous. I'm in the process of getting my documentation fixed, but I'm really nervous it's going to come out during the questioning for loss of earnings. And so walking through that, but like building that trust for him to open up, because the question potentially could have been asked in deposition. And if he wasn't prepped, then how do you answer?
Right.
And same thing with like prior crimes. It comes out later on, but if you can sort of build that trust early on in the case where the client feels comfortable telling you, look, I've got these I was 16 years old or whenever it happened and I had these run-ins with the law. This is what they are. This is what, happened. How is that going to impact my case? Because I think it does impact a case to a certain extent. Have you had any experience with like crimes with clients?
I think honestly, a lot more of what I've dealt with is like prior accidents.
Yeah.
Or prior injuries to the same part of the body that is now exacerbated from whatever incident that they've been in. And I think a lot of time that is something that's really nerve-wracking for a client because it's like, well, I don't want it to look like I'm just, faking for this case when really I was hurt in the past.
Yeah.
And, that's not their reality, but it might be the narrative of the other side, which might make them nervous.
Do you feel like the majority of your clients tell you about these prior incidents, or is it because you're pulling their medical records and then looking through and trying to identify them?
I'd say the latter usually happens a lot more often.
Yeah.
Or like when we're going through discovery and one of the questions is like, have you been in any other kind of incident and hurt the same parts of your body that are being claimed? I feel like that's a lot of the time when it'll come out. And I think a good chunk, that's not the first time that I'm asking about it.
Yeah.
But I think when you have this idea of like, hey, like these answers are really important. We have to verify these answers. These answers need to be as accurate as possible.
Yeah.
Sometimes the weight of that, makes someone a little bit more like, okay, there was this thing, but, so I think then it comes out a lot, but I always try and get it out way before then. Like in one of my first calls, like, hey, have you ever hurt this part of your body before? I think a lot of the time, like us as human beings, like we sit all day long. We might have jobs where we stand. So like our back is going to hurt, or we might see a chiropractor, or we might do some treatment for it, but that's not the same as having to get a super invasive spine surgery.
And I think the thing that always trips up clients is you ask like, have you ever had any prior injuries? And it's not always an injury. Maybe you slept on your neck weird and the next day you went to the doctor and you mentioned it and now it's in your medical records. But then it resolved and all of a sudden it comes up as like an impeachment issue where they're like, haha, you lied. And it's like, no, I just completely forgot about that one time 10 years ago.
Right. Like me sleeping weird does not come up when I'm thinking about this like traumatic event I just went through.
Yeah.
Like, like a lot of the time it's a weighing game in our brain, or it's like those aren't coming up because I haven't had to think about it for so long.
100%. And I think sometimes, I don't know if it's, a client trying to like help their case, but they'll just answer in the ordinary intake. They'll just put, have you had any prior injuries to this body part? No. And I don't know if it's them trying to help their case or not trying to hide anything, but you really have to like weed through and make sure you're talking about those so many times, because once it comes up in the medical records, they're like, oh my gosh, I need to disclose this. And I hope hopefully you caught that before your discovery responses, but.
Yeah, I think like, do you have any type of, I don't know if tactics is like the correct word, but like how do you usually like to kind of set the stage for a client to open up about those things?
So similar to you, it has to be before discovery. So for example, I just got a case and I know that she has prior, the referring attorney mentioned that she had prior issues with her back. And so I just bring it up. Like, I'm like, look, it's very important for us to know the full scope of any prior injuries or just prior visits to the doctors for the specific issue. And then, I'll go 10 years back. So I'm like, in the past 10 years, have you had any sort of pain or prior issues with your back? And it doesn't even have to be like a significant injury, just anything that comes to mind. And maybe they say no. So I'm like, okay, that's fine. We pull their medical records, getting closer to discovery again. Look, we pulled your medical records. We're trying to answer in the most clear and concise way for the specific question that the opposing side's asking. Do you recall telling your doctor X, Y, and Z? And typically it's in the complaints. Like I was on a roller coaster and something happened with my back, something like that. And then sometimes that will jog their memory. I try to be delicate though. I don't want it to appear like a I got you moment.
Right.
And so it's just, look, we need to make sure these responses are 100% honest because you're signing under penalty of perjury. And then typically once I read from the specific document or I've refresh their recollection. I'm like, did you, see this chiropractor maybe like 5 years ago? And they're like, oh shoot, yes, I did. It helps refresh it. And then it's not like an attacking way. Because I think that's the delicate balance too.
Totally. And I think it's kind of goes like with what we've been saying, where I think a lot of the time I'll preempt things exactly how I said to you, where it's like, maybe if I see that they're in customer service, I'm like, okay, they have to be on their feet all day long. Like I am sure there has been days at the end of the day where they're just like, oh my gosh, my lower back is killing me. So it's like I sometimes preempt it. Like, I'm sure that you have experienced X, Y, and Z because operating in this world, like we're going to have some pains. Like that's just reality.
Yeah.
But it's my job to be able to differentiate that, because I don't want the other side to ever find something and be like, oh, they're lying.
Yeah.
Because you're not. Like I can hear that you're in pain. I hear the impact this crash has had on you. And so it's kind of letting them be like, let me advocate for you in the best way possible. Like just give me this information and then I can differentiate it.
I say this to them all the time. Your job is to give me the facts. My job is to advocate. So you don't have to advocate. I say this during demo prep. I'm like, you do not have to advocate. Just tell me the facts. And then as long as we have everything, we're good. But if later on in your deposition, and the reason I brought this up is I had an issue with prior criminal history, which wasn't detrimental to the case at all, but phrasing it and prepping the client properly and making sure we disclose it. We had 2 prior felonies. The client was the most amazing, sweet man, and he was actually in the process of expunging them from his record. And so we'd fully disclose them in discovery. And then in his deposition, the question came up and he was prepped, he answered, and he was like, I was young. Unfortunately, I was charged and I was convicted and I have a felony on my record, but I'm in the process of getting that expunged. And I know some attorneys will instruct their clients not to answer. I thought for our case with the injuries we had were significant. It was a pedestrian versus vehicle case. And I honestly thought that him talking about it was more forthcoming and honest. And I think it helped us.
Totally.
And we ended up settling the case before going through all depositions and everything. But I think it really helped. But
well, yeah, because it shows like I'm not hiding anything and I'm not presenting myself as anyone but who I am today. And so like I, might have a past, but that doesn't define who I am today. And I think allowing them that space to really like say that, like you can feel that genuine nature coming from someone.
Do you also tell your clients like, we have to be consistent? And how does that play into like, for example, when you prep them for depo, like what do you kind of tell them?
A lot of the time I'm like, hey, we have nothing to hide. This is your opportunity to tell your story. Up until that time, a lot of what the legal process has been is paperwork.
Yeah.
The other side may have seen your medical records, have seen your discovery answers, might have seen a demand by that time. The deposition is their opportunity to present themselves and put a face to all of their pain that they're feeling. And so I always want to hammer in like, this is your opportunity to tell your side and your reality of like what happened and its impact on you. So I think that's something that I really hone in on and let them know, like, it is exactly like you said, like, it's my job to advocate for you. Like I am there to make sure that you are not taken advantage of and that you are given the opportunity to say what you need to say.
That, and I always tell them like, this is the time. So your medical records are very black and white. They don't tell the story of what your pain was like from this. Like, let's say they had a prior fall and it resolved after 5 months. And then 2 years later, they have a significant car accident. That's the time to differentiate. So I'm like, this is when they start asking you questions about this prior injury that resolved and has nothing to do with your current injury. That's where you really need to differentiate. Was I in pain every day? No, my pain lasted 3 to 5 months. And then after some chiropractic care or who knows, massage therapy, it went away. Now I wake up every day and I'm in pain every day. So like really contrast it so that later on it's not taken out of context. Because I think a lot of things get taken out of context, especially once you get closer to trial and, medical records are used as exhibits and things just the story isn't there. So I'm like, please be consistent, be honest, don't try to hide anything. And then differentiate your pain for anything prior because it's 90% of the time it's totally fixable. And the way you answer those questions can be crafted very strategically but you have to know about everything. So
Yes,
that's
definitely.
the frustration.
I know. And do you think maybe should we back up and explain what a deposition is?
Yeah, we can.
So a deposition is the opportunity of the other side to say we're doing like a plaintiff's deposition. So that's the opportunity for the defense counsel to ask questions of the plaintiff. They are under oath, so they need to tell the truth. And usually, I mean, in this day and age, we're doing a lot of Zoom depositions, but they could be done in person. So usually you have a videographer, a court reporter, the defense, whoever's being deposed, and then the plaintiff.
And
counsel.
sometimes you'll get the insurance carrier.
Yeah.
I've had that on a couple of cases.
I have not experienced that
It's
yet.
very weird.
I can imagine.
But yeah, so deposition is the one opportunity that the opposing side gets to ask your client questions. And so I always tell my client, like, look, this might be nerve-wracking, but as long as you're honest and consistent, it'll be fine.
Yeah.
And I think the first couple moments, they're a little bit nervous, but once you get into the swing of things, it's fine. And I always tell them, like, please take a lot of breaks, because I don't want you to just get into the habit of saying yes, because you're tired. And then that one question that you weren't listening to, you said yes and you weren't listening, and all of a sudden now you have a contradiction. So
yeah,
I take a lot, especially with Zoom depos. I take so many breaks.
Yeah, absolutely.
Yeah.
Yeah, I think that's smart. And I think hopefully by the time that you're in the deposition phase, you've had so many conversations with your client that you guys are kind of already on the same page. You don't want, like, before the deposition for you to be hearing things for the first time.
100%.
So hopefully by that time you've built up that rapport, which is exactly like what we're talking about, is building up that trust. And I think something that's also important to talk about, it kind of goes to what you had said, where it's like, I'm not trying to like have that aha moment, like, gotcha, because this is your client, you're their advocate.
Yeah.
But I think it's also important because we aren't historians. You know, it's not our job to sit down and remember every single detail of every part of our life in one sitting. Like, that's, I want to say impossible, but
honestly,
it
is
incredibly difficult. So I think it's like one of those things where sometimes I'll be asking my client the same question every call.
Yeah.
But I do it in a way where it's like, hey, I don't want you to think I'm not listening to you.
Yeah.
I don't want you to think that I'm not taking notes, or that I'm not paying attention, or that I just didn't like your answer. I'm just going to ask you again, just because I know maybe something has, reminded you of something that you didn't think was important to mention the first time.
So since we're talking about prior injuries, one thing that I know our firm does is we run ISO reports, which ISO reports are these reports that you can pull that list any prior reported claims. And so you get this report with your client's name. Sometimes it includes just property damage, prior claims. Sometimes it includes things that are very relevant to your case, such as a prior collision with injuries, but the information on those reports is very limited. And so do you sit down with the client and go through the ISO report before their deposition? Okay, yeah.
Every time. Usually during discovery.
Yeah.
Or definitely before discovery.
Yeah.
I sit down and I'll look through it, and I'll ask them first, like, hey, like, do you have any prior collisions? Do you have any prior claims? Do you have anything that is searchable? Because if we can search it, the other side can also search it, and they will search it.
When I was on defense, 100%. That was the first thing we did. ISO report, and immediately went through, like, which ones look like it could be relevant.
Yeah, because sometimes they can be super detailed, where it's like collision, property damage, collision, or one will be like claim, like theft. You know, like maybe they had a report because someone broke into their car. Like, you can sometimes see like little blips, but you don't know really the extent. So I think I will ask them first, and then I'll be like, okay. And they know that we're running that search.
Yeah.
So then I'll be like, okay, does this date ring a bell? Like, I have this information. And then sometimes it'll be like, oh, that was when I was under my mom's insurance. That wasn't me. You know, and then you can kind of go through it.
So many times it's like, oh yeah, that's my son, or oh, that's my wife. That's my wife's car, or my cousin was driving my car. And I'm like, okay, let me just write that down.
Yeah, exactly. Because it's like, I don't want to hear a date and be like, oh gosh, I didn't know about that. And it's like, wait, no, I have this note right here. We already are in front of it.
What about one issue I've kind of encountered is with older clients? Maybe, I have a client that's 80 years old, and it's not that he's not a good historian. I just think he's just generally just doesn't remember certain things. do you then try to talk to family members, or how do you go about trying to find out priors or trying to find out anything that might be relevant for a deposition?
I try and do a lot of what we've already talked about, where it's like, I'm going to go through your medical records. I'm going to ask for your primary care physician. You can get so much in the primary care physician documents, because those medical records will have who they were referred to, who they might have had prescriptions sent, like so many informations where like maybe that client is not remembering the PT or the physical therapist that they went to in 2012, but maybe there's a referral in their primary care physician records. So I think taking time to go through those, maybe taking time to look through, and if we're talking more so just like injury based, maybe I'll look like, hey, I saw that you had complained about your back pain in 2010 from a little like from you tripping on a step. Like, did you ever treat for that? Do you have any recollection? And then kind of going there. I usually like for the information to be coming from the client themselves.
Yes.
So it's almost kind of like leading them to it. And then if they aren't there, then like that's going to be consistent. They don't remember.
Yeah.
And so I never want to feed them anything, but I also want them to like.
Right. Because then you're like sparking in memories.
Right. Where it's like, okay, did we suppress something? Like, what about you? Do you go through it kind of the same, or?
It's hard. So for TBI cases, so TBI means traumatic brain injury. If the injury is significant enough, they honestly sometimes just don't remember.
Right.
And so I've had it where I just have to talk to like the spouse, and maybe the spouse has a very clear recollection because they took the patient or the client to every appointment to the surgery. And so it's tricky. Sometimes I do talk to family members, and sometimes those conversations will be like, oh yeah, there was this not prior injury, but maybe there was something relevant to the case. And I'm like, oh my gosh, thank goodness I spoke to you, because our client is not the best historian. He doesn't remember. So I think with certain clients, you can create the space where they feel that they can tell you certain things, but maybe they just don't remember. So then building that space also with the wife or the spouse, or a close friend that knows a little bit more to pull that information. The last thing before we wrap up for the day, how do you create that judgment-free zone for a client? And we kind of touched on it already, but any tips on how to make a client feel comfortable with you?
Yeah, I think it starts from the inception of their case. I think when you're assigned a case, you should hit the ground running in trying to make a relationship with that client.
Yeah.
One where it's like, hey, I want you to know what my role is. I want you to know how I'm going to show up. So I think words and actions should always align. I'll set an expectation, because I never want to blow the expectation that they have in their head, because, maybe like I have no idea what they're expecting from an attorney. Maybe this is their first, actual time dealing with one, and so I don't want them to be expecting me to call them every single day, because it's not going to happen.
Oh yeah,
like there just isn't time for that, and there's not always information to give them daily. So I think it's asking like, hey, what is your comfort zone with the amount of check-ins that we do? What's your preferred line of communication? Kind of giving them the space to like tell me what their expectations are, and allowing them to know like what I can and cannot meet.
Yeah,
and so I think that's important to start. And then also just like letting them know, like, I am your advocate. I am here for you. And so I'm going to continuously show up, and then like showing up, you know? So I think also letting them know, like, whatever you tell me is in confidence.
Yes.
I want to advocate for you best. I want to be proactive instead of reactive. I want to be able to control the narrative. I want to be able to do you justice by explaining things correctly, instead of making it seem like if the other side says something that like I didn't know, I don't want to not be in the know about your case. Like I cannot effectively advocate for you if I don't have all of the pieces to this puzzle.
I love that. The only thing I would add to that is I've recently started telling clients like, look, if there is another issue that's going on in your life that may be completely unrelated to your case, you can still tell me that, and I'm here for you. And the reason I bring that up is, sometimes I have a client right now that's in the middle of a divorce. And so she has not been answering my emails. And so I'm like, what's going on? Like, you're usually very responsive. You're not answering my texts. And she's like, oh my gosh, I'm so sorry. I'm going through this divorce, and I've been swamped with my divorce attorney. And I'm like, oh, okay, perfectly. Like, but we've built that relationship where like we text all the time. And so like, I know that, or with another client, just letting them know like, look, I might not be X, Y, and Z type of lawyer, but I know other lawyers. And so if you have another legal issue, like please feel free to reach out and I can connect you with some people, give you options, because sometimes we're the only attorneys that they've ever encountered. And so knowing that you can lean on us for help, even outside of your case, like we're here for you, even after your case resolves. I've had clients that keep in touch and they're like, look, I'm doing well, but I have this girlfriend and I know she had this issue. Do you think you can help her? And maybe it's not my specialty, but I know other attorneys. And so I think it goes beyond just the lawsuit, the case. It's building that friendship with people, because at the end of the day, that's what people want. They want that attention and that one-on-one friendship. Yeah.
No, I think that's so important. And I think that that's why we try and keep that like at the core of just like,
I love it.
You know, people want to be treated and respected and like met where they're at.
Yeah. And I think that's why clients come back.
Yeah.
It's not necessarily the amount of money you get them. It's how you made them feel. That's what they remember. So, well, thank you so much. I think that's it for today, guys. So today's session was about building rapport with your client. We're going to continue making and releasing different topics. So stay tuned. Thanks, guys.
See you next time.